access. I'm going to share my screen so you can see my PowerPoint. I did email Miss Angel the PowerPoint in case anyone would be interested in having a copy of it, but let me just see if this works. Share, and I'm gonna, from the beginning. Okay, are you guys able to see this PowerPoint?
Yes.
It's showing, okay, great. I'm not the most technologically advanced, but I am running a virtual practice. So yes, as Ms. Angel said, I'm the founder of a special education, special needs law practice, MSR Legal and Consulting Services. Those initials MSR actually stand for my children's first names, Madison, Scarlett, and Riley, 2 of which have IEPs and 1 who is OPWDD eligible. When I started this, working in this field, I wasn't a parent. I just kind of fell into it and fell in love with it. And now using the skills myself that I've learned over the past 14 years. So this first slide is just a list of all of the topics that I hope to cover. You know, I'm going to go through each one pretty quickly because of the time constraints, but each of these topics could be its own hour-long presentation. So just understand that I am touching the surface. And in terms of this presentation, I have some fine print on the bottom of my first intro slide that this is not considered legal advice. This is for, you know, general informational purposes, you know, community education for the public, and that there's no attorney-client relationship being formed by virtue of me, you know, responding to a specific question. I just have to give that disclaimer. So consent and confidentiality. So I start here because this is really where it all begins. And for all of the parents here that have children with IEPs, you should have been, you know, given informed consent of the evaluations and why they're being proposed and what the evaluation will look like of your child. It's important to note that consent to evaluate is not the same thing as consent to the provision of special education services. So it's really a 2-part process, and you don't necessarily need to get to that second part. A lot of parents, you know, don't really realize it, and they're like, no, I don't even want to have my child evaluated or reevaluated. But it's interesting, this is embedded in the law and the commissioner's regulations covering children with special needs, that you know, you can consent to evaluation and not necessarily consent to the actual service. You know, of course, that not allowing the service to actually take place, let's say, you know, consenting to a speech evaluation, but not allowing your child to receive the actual speech therapy, of course, down the road, that can potentially pose issues if your child ends up struggling, and then now you're looking to figure out how to catch your child up. But those are definitely 2 different consents, and I do like to let families and, you know, individuals who work with families know that consent to one is not necessarily consent to the other. Prior written notice is very, very important. So as you all know, you sit through the IEP meeting and you know, there's discussion, of course, about the different parts and what your child functioning levels are and what they need. But the prior written notice is really the DOE's kind of final notice of recommendations. It's usually accompanied by a school location letter for public school students, you know, 5 and up. And this is really what you will receive and know, okay, this is what the DOE is intending to offer my child as an appropriate set of programming and services based on the education. And another reason why that prior written notice is important is if you end up disagreeing with this, ultimate recommendation. It's really just important to know what that recommendation is, and that is what the prior written notice, or PWN, does. And then, a slightly controversial point, but I am in favor of giving families information and having them come to their conclusion. Families do have the right to revoke consent altogether to special education. In my 14 years, I've only seen it happen once, where a parent wanted to sort of decertify or declassify her child from special ed services, from IEP services, altogether. And of course, it's a huge decision and something that should not be taken lightly. And there could be potentially, consequences, again, to taking that position. But it's important to know, even though the Department of Education wouldn't be able to force you by, let's say, an impartial hearing against you to, force a parent to continue with special education, there are potentially, child welfare consequences that the parents should be made aware of if the mandated reporter feels like the parent is sort of standing in the way of the child receiving an adequate education. And that's where education neglect referrals can happen. So language access, you have the right to meaningful participation in this CSC process, the Committee on Special Education's process of developing an IEP and finding the right school placement that can implement the IEP. So to that end, there should be translators or an interpreter at the IEP meeting. The regulations say that districts should make every effort possible to make sure that the meetings are taking place in the parent's native language, if that would otherwise pose a barrier to the parent participating in the meeting. At an impartial hearing, which I'll go into later on, you do have the right to an interpreter at the expense of the Department of Education. And for your child, I see this with recent immigrants, there's the option of, or the option available of bilingual instruction and bilingual speech and language therapy. It's all based on your child's needs. And there are programs that do offer, I've seen, Spanish language and Mandarin, and there may be some other languages as well. So I like to think of language access not only for the parent, but also potentially for the child, him or herself. So this is a big one, the free appropriate public education. So we use this acronym, as you guys know, parents know, there are a lot of acronyms in special education, but this is the most important one, FAPE, the free appropriate public education. So we know free means that it should be at no cost to the parent. So just like you say your neighbor who has a child without a disability doesn't need to pay for her child to get a proper education, you as a special needs parent shouldn't have to pay either. So it's sort of like an equality or equitable thing with the no cost to the parent. Appropriate is where I do all of my litigation because it's so specific to the child. So there's a lot of case law, like judges' decisions that have molded what it means to be appropriate. But at its most basic level, the services have to be tailored to your child's needs. When I'm reviewing an IEP, I'm looking if the parent is telling me, their child is a non-speaking child, then I'm looking to see if there are, strategies and goals relating to functional communication or, things like assistive technology, and we'll get into that. But it's got to be tailored to your child's needs, right? It shouldn't be sort of a template form, in terms of the IEP. We should be looking at your child's functioning levels and seeing how we can help make that child make progress or demonstrate progress over usually a calendar year. Related services are very much a part of the appropriateness of the IEP. A related service is any service that a child needs in order to access or benefit from the instruction. So I put therapies because that's, a lot of us are really familiar with OT, PT, and speech therapy. But transportation is a related service as well. So the ability of your child to get from your home to the school is a related service. And so that's why certain IEPs have, different transportation accommodations and, wheelchair lifts and a transportation aid. I even did a case where we had an aid that could bring the child from the door of their apartment down their walk up, because the child was in a wheelchair, and the parent and the home health aide weren't really able to do that kind of transportation. So, I put that there because it's really important. Also the length of the bus ride as well. Assistive technology, I see it most commonly in the context of communication, but under the law, it's broader than that. So I am working, for example, on a case where we're trying to look at assistive technology in assisting a child's mobility needs and a certain chair, adaptive chair or adaptive stroller within the school environment to really enable that child to participate more fully in the instruction. And of course, nursing services, paraprofessional services, all of that has to, go into the child's ability to access and learn in the classroom. And appropriate means it has to be able to produce progress and not regression. And this may sound, like a really simple, a concept that, shouldn't be worth saying at all, but it is because, we see IEPs where sometimes from year to year, it's not changing, and yet the child is still not making progress. And so, there was a relatively recent, like 5 years ago, a US Supreme Court case that talked about how, the district is on the hook here. You can't just kind of like copy and paste last year's IEP and keep it moving for this child who has not made progress. So something has to change, in the IEP, in this placement. And that case, it's called the Endrew case, ENDREW case. That's where the Supreme Court, US Supreme Court, talked about how the goals have to be challenging and ambitious in light of the child's circumstances. So it just we can't just be creating these IEPs just for the purpose of doing that without a real mission in mind that we do want to see progress, see demonstrable academic or pre-academic progress or physical developmental progress in the child from year to year. And to that end, sometimes we do have to create goals that are going to push, not only the child, but the educators in the room to really help that child achieve what they should be achieving. Otherwise, the education will look more like, okay, this is just childcare, this is not, education if we're not pushing the child in that right direction. And public education, it means it's aligned with grade level content standards for children who are in special classes. For example, it's, the grade level content standards have to be broken down and modified to a level that the child can understand and access. And then meaningful parental participation, I bring that up again. The Department of Education, just speaking, to you parents out there, has to afford you meaningful parental participation. So you shouldn't feel like you're walking into an IEP meeting where everything has already been thought up and planned out, even before you step foot or offered an opinion, and that you should feel that it's a space where you can voice your opinion. And I talk more about that on the next slide. So in terms of your rights with respect to the IEP, you have the right to share reports from outside providers. So often I see parents wanting to bring their outside, if they have private insurance and their child's getting ABA, applied behavioral analysis therapy outside of school. Sometimes they'll bring that supervisor to talk at the IEP meeting. Sometimes they'll bring a prescription from their developmental pediatrician who's recommending a certain number of therapy sessions or a certain teaching methodology. I see that with my clients on the autism spectrum, but you do have the right to do that. And I encourage families, if they do have reports or outside information to share that has bearing on the child's education, to share that in advance, with whoever the administrator is for that IEP meeting. You also have the right to bring a family member, an advocate, an attorney, if you feel that's warranted. The law is really clear on that you can bring the support person or team that you need, as long as they have specialized knowledge about your child, and can really serve as a productive member of this committee, the Committee on Special Education. And another thing, you're allowed to give suggestions on the goals. So sometimes the annual goals are glossed over, by the parent, because it can seem like very heavy, like we're talking about like the number of times a child is going to do something within, at 80% accuracy level within 4 months. It can sound all very technical, but nothing stops a parent or their advocate from saying, you know what, I don't really get all of these different terms that you're using, but I'm concerned that my child doesn't know the alphabet, or I'm concerned that my child hasn't learned to pull down his pants at the potty, and so I want a goal about that. And that's absolutely your right to raise your real world practical concerns in your own voice. And they are supposed to address it. That's what it's comes down to in terms of meaningful participation. In various sections of the IEP, there'll be like a parental concerns section. For preschoolers, for example, it's kind of spread out between some of the different sections, the parental concerns about physical development, academic development. And when I, attend IEP meetings on behalf of clients and even for my own children, I can say, please note in the parental concern section that I have an issue with this or that I disagree with that. And they are supposed to note that. And I see that, often in IEPs that the parent disagrees or the parent feels this child needs X, Y, and Z. And so that way it's documented that you had concerns, you tried to raise them, and that can help if you end up having to take the next steps, which I will, talk about in the next couple of slides. But you don't have to agree with the special education recommendations. So if everything goes well, you won't need me necessarily, if you feel like the IEP developed is appropriate, and you go and visit whatever placements are offered, and it looks like it'll be a safe environment, therapeutic environment for your child, then there's really no need to necessarily disagree. You give it a shot and see how that works. And so oftentimes that can be the advice that I give families, like, it kind of looks like a solid IEP. You didn't tell me there was anything glaring when you went to visit the school, if they're still giving visits. I know certain schools have, COVID policies. But if it's the opposite, if you walk out of that, virtual IEP meeting and you're like, oh my goodness, I really felt like I wasn't heard. I really am concerned that they're not recommending this particular therapy that his doctor's recommending. You just know that you don't have to agree to the services. This plays into kind of the consent confidentiality slide, but more so this plays into kind of moving forward what rights parents have when they do disagree. So issues of least restrictive environment, this is embedded in all of the laws covering special education, from the federal down to the local, regulations, your child has the right to be educated in the least restrictive environment, in which he or she can learn. So that's really the qualifier is, a parent may want their child in a general education setting, but we have to think about what is the least restrictive, in which that child can really meaningfully access the learning and education. There's a whole continuum, from general education all the way through home and hospital instruction is like the most restrictive. In between is where we have, some District 75 schools. We have, day programs that are state approved, residential programs as well. And, this is an important piece. I've been, I think as times are changing and society is looking more progressively at the issue of integrating children with disabilities with children who don't have learning differences, or maybe not identified learning differences, I am seeing more often some families asking for the child to be in some sort of inclusion setting. And I know the DOE has or is piloting certain programs with that regard. But in terms of knowing your rights, it's, least restrictive environment is a pretty important one. I think it really stems from back in the 70s, when these laws came about. The special education grew out of the civil rights movement, racial segregation and integration. And then the disability rights groups started popping up and saying, well, what about us? We've been segregated as well. And, being close to home is a consideration. Interacting with typically developing children is a consideration. Proximity, the zone school, your local community school. And so you're kind of in the position as a parent of thinking, well, going along the continuum, at which point is it that my child is in the least restrictive environment? And, all of those considerations, also the size, the class ratios are embedded in this concept of, making sure that the child is not unnecessarily placed in a special class with only other children with IEPs. So the independent educational evaluation, this is a big one, at least in my practice. You have the right to disagree with your child's evaluation each time an evaluation is conducted. And the evaluations are important because those are what serve the basis usually of the IEP developed. And so if your child had a bad day or series of bad days, or you just felt like the evaluator's report doesn't quite capture your child and how you view your child and your child's needs, you have the right to disagree. And I think that this is actually a really powerful tool, advocacy tool and litigation tool in our toolbox for parents who are, looking for something different than what the district may be offering. You can think of an independent evaluation as a second opinion. Like if you went to a doctor, you got a diagnosis and you're like, well, I need a second opinion. And you can think of it in that way. And that second opinion has to be discussed and brought to the CSC, and to determine whether changes need to be made to the IEP. So independent means that it's a non-DOE employee. It'll be at, publicly funded at the DOE's expense. And if you find the right provider, that independent evaluator can actually clarify certain diagnoses. Like sometimes I have families that are, I think my child might be dyslexic, or I think my child has ADHD, but they just never had the means to kind of narrow down or rule out certain diagnoses. In certain cases, an independent neuropsychological evaluation can do that. And from an advocacy standpoint, I like the independent evaluations because they usually come with recommendations for strategies and teaching methodologies that would be effective for your child. So unlike sometimes the evaluations we see from school districts, where there's an analysis of the child's testing results and functioning levels. At the end, usually those evaluations say, and we defer recommendations to the CSC, to determine what IEP services may be available. With the independent evaluations, you get recommendations like your child needs ABA or your child needs an extended year program, or your child has autism and ADHD and needs compensatory education. So it is a sometimes overlooked but very powerful tool. So I wanted to throw in here some special education rights with respect to being disciplined. And I don't know how often this is happening in the District 75 network, but to the extent a child is suspended for a period longer than 10 days or has been suspended cumulatively for a period for more than 10 school days, there should be a superintendent's suspension hearing whenever school is seeking a long-term suspension, or it's called a long-term suspension. And if your child has a disability or being suspected of having a disability, there should be what's called an MDR. We call that here in New York City the manifestation determination review, which should look like an IEP meeting where the team is looking at the alleged misconduct and in relation to your child's disability, and determining whether there's like a substantial relationship between the two, because the idea is that your child shouldn't be punished for behaviors or conduct that's pretty much out of their control. And the MDR, if it's done properly, should be an opportunity where the committee decides to move beyond punishment, but also tweaking the IEP and considering changes to the behavior intervention plan, or for the first time conducting a functional behavior assessment. So that all of that happens if things are done the way they should be done. Your child does have the right to IEP services during long-term suspensions, and that's always something that may not happen, I guess. It's hard to kind of recreate a special education classroom when a child is on suspension, but there is, in terms of your rights, an expedited impartial hearing process. It's a process that should, from start to finish, be completed within 30 days, where you can appeal sort of the MDR results. So if the result is that they say there's no nexus, there's no connection between your child's, having ADHD and pushing a child, near a window, then there are things that you can do to appeal. One of them is this expedited due process hearing with respect to the suspension, and also the receipt of services during the suspension. So due process. So this is like a very charged legal term, but essentially I describe it as, if your child has this legal right to an appropriate education in New York State. It's a constitutional right to be educated under the New York State Constitution. And before a government entity, such as a school district, can violate your rights or impedes on this right, you have the right to challenge it. And so that's kind of what due process is all about. There are different ways in which a parent can, disagree and challenge and ask for something else. The simplest way is really the reevaluation. Some parents say, I think my child really needs a paraprofessional. This is ridiculous. I'm getting called every day to pick up the child, and yet they keep denying me the paraprofessional, and now I'm going to lose my job because I can't go to work, that whole thing. And, I always say, well, try and get some letter and support from an outside provider before you ask to reopen the case. But that is, one of like a starting point, I think, in terms of advocating for your child. There's mediation. Again, like each of these could be its own PowerPoint presentation, but that is supposed to be a non-adversarial process in which both sides get together with a neutral person, the mediator, to try and come to an agreement on what changes to be made. We usually don't see anything that involves private funding, private schools, private tuition, or tutoring, or ABA services that cannot really be addressed in the mediation, because the individual sent to represent the DOE often doesn't have that legal authority to bind the DOE to fund things of that nature. A state complaint is good for alleged violations of patterns and practices, or just an overall violation of your child's rights beyond what the individualized services you want your child to receive, but to just let the state know, like, well, this is what they're doing, and this is what the school district's doing, and it's a violation. And the state comes and does an investigation and interviews both sides, and then comes up with a finding of whether or not the district has violated or is violating special education laws. The impartial hearing is really where I practice the most, because that is the most targeted venue for your child's needs, where you're not kind of limited to only changes within the IEP, but it can go beyond that to things like private compensatory education funding, and private school potentially, and after school services. So I see my slide. Okay, I hope you guys can see the whole thing. But compensatory education, since I've been doing this virtually since the pandemic, this is huge. It's still huge. I still see, when I'm reviewing records, IEPs, where the child is not, there's documented, evidence that the child didn't really access the remote learning for a whole variety of reasons: disability, age, behavior, lack of someone who can facilitate that. So it's important to note in New York City that the statute of limitations has been told, meaning it's kind of like the clock stopped between March 2020 and November 2020. This is very technical, but typically a parent only has 2 years to raise concerns about their child's education. So the information I'm putting forth here, which is not necessarily legal advice, is get your claims in before November 2022 because of that 2-year statute of limitations. If you're looking for makeup services to make up for past denials of FAPE, of the free appropriate education. With compensatory education, there's quantitative approaches and qualitative approaches. By quantitative, I've done cases where it is, the parents like, my child missed 50 seconds of, 50 sessions of speech, and I want all 50 sessions back. Qualitative approach is more thinking as a whole. When my child didn't really access remote learning by the special ed teacher over the course of 2 or 3 years, so I want to make up for that. And I think that having private sets by an ABA trained teacher is what my child needs to make up for that deficit. So again, all of this is a lot that can be addressed in its own PowerPoint, but I just wanted to touch on all of it. And now, beyond after school beyond compensatory education, which is really specifically to make up for past denials of FAPE, there are kids who just automatically I mean, somewhat automatically need the after school services. So a child's school day doesn't necessarily need to end at 2:30 when they get on the bus to go home. I have a lot of clients who have additional support, as long as, it works for the family, in terms of their childcare arrangements and dynamics, to have an outside provider, funded by the Department of Education, come in and work on all of these skills, toileting, communication, self-regulation. For my older kids, travel training and community skills. Under the law, the standard is that it has to be like necessary. It has to be like a necessary component of the child's special education program, so that without it, the child won't make progress. So it is a pretty, high standard to meet. But when you think about the possibilities of, instead of coming home and dealing with your child yourself, along with all, if you have other children or other work obligations, you can have a trained individual, free of cost, coming in and helping with all of these skills to transfer them over. And I, most commonly see it, with ABA, the Applied Behavior Analysis for the children on the spectrum. And then private school tuition, this is like the most complex of the, remedies or relief that parents have available in terms of the advocacy and litigation involved, but I did want to bring it up. So you essentially are kind of thinking like, is my child one of those children who just doesn't quite fit into the special class ratios that are offered? Is my child, not quite a 12:1, but 8:1, would it fit for him? Or are they somewhat in between some of these, in between, a 12:1 in a community school versus a larger class, inclusion class in a District 75 program? So these are all kind of the conversations that are had, at least between myself and parents, where they feel like they want to take this step and look outside of the public school system. Does your child require a particular teaching methodology? So like my clients with dyslexia, which is now called like a specific reading disorder, in, it's specific learning disability in reading, or in Gillingham or Wilson reading, or methodologies. Of course, there's ABA for autism, floor time, just different teaching methodologies that may not be fully present and utilized in your child's current school. But if you do have that evidence that your child really requires this, either through an outside evaluation or a medical report, that could be something that can add to a case for funding. And there are two different types of private schools. There are the ones that are approved by New York State. They're called sometimes NPS, non-public schools, which the DOE, through their central base support team, can identify if they do kind of go through this analysis and feel like there's no public school that can meet this child's needs. And then there are non-state approved independent schools that are out there that target different disabilities, and a lot of them are in Manhattan, a few in Brooklyn, more popping up in Queens, very few in the Bronx. Unfortunately, there's one. No, I don't think there's one, at least a non-state approved independent school in Staten Island. But there are schools out there, and families sometimes come across, they start Googling like, autism school or dyslexia school, and some of these schools will pop up, and that kind of kickstarts the research that the parent has. So I know I went over my time. There was extensive discussion about transition planning. In terms of your right, the whole goal is to have your child be able to lead as productive a life as possible after high school. The vocational assessments should be happening at around age 12, the transition planning, that IEP in which that school year where the child's turning 15. Your child also has the right to start, to be invited to attend these meetings if you feel that is what, is appropriate in those circumstances. And, I've done cases for private transition services. If you feel like your child needs more than what's offered, there is potentially, ABA type or, private agencies that can, take on that role after school of doing the travel training and vocational training. And then lastly, your child's eligible as long as he or she hasn't graduated with a diploma, eligible for an IEP until they're 21. And that's it. And this is my contact information. I'm sorry for going over, but I'm, ready to take any questions.
This was very valuable information. Do we have anyone that wants to raise their hand for a question? I checked the chat. There isn't anything so far. I do have a question while we wait for a question. Could you explain the necessity or why it would be good to have the special needs trust funds?
Yes, absolutely. So I think it becomes more important as the child is growing up and reaching that transition into adulthood. So now, like through OPWDDs, like there are different waivers. For example, the parent's income can be kind of taken out of the equation in terms of how, whether the child would qualify for like, Medicaid services. And, I think the importance with the special needs trust is like if your child does end up having some income or inheritance, something that would impact their eligibility for income-based government assistance like Medicaid or I think SSI, I guess, other food stamps, things of that nature, that putting that kind of like just thinking of it in a very like simplistic way is like putting that excess income away, so that it's not shown when the government is, whatever agency is looking like, okay, how much, in assets does this individual have, can enable the child to qualify for, those government benefits that are needed for their, survival. And at the same time, still have access through the trustee for, their care through the special needs trust. So, special needs planning, it's important, especially as, we enter into those transition years, the teenage years, and, being practical and thinking like, well, yes, my child, you think like child's always going to live under my roof and I'm going to be able to take care of all of their needs, but then what happens if that's not the case, and we never know what. So it's almost like trying to be able to set the child up to, when you're not capable of being their everything and primary caregiver. And, it's a separate legal process. The child for special needs or supplemental trust, there is a certification. There has to be like a medical certification, I think, by 2 different doctors certifying the developmental disability. And the trustee or the proposed, trustee has to, the family members have to be notified also that this is happening so that they, potentially have a voice or a say, and, the appropriateness of whoever ends up being designated. There's the succession planning of like what happens after that, individual with a disability, passes on, and who ends up being that contingent beneficiary. And there was a case actually that I had looked at fairly recently where a judge said that this particular young woman, didn't need kind of like the type of guardianship over property and person that her mother was seeking to have under her, and said that, this was a child who, not a child, no longer a child, but a young adult who had the means to manage certain these financial aspects of her life without kind of the guardianship and that comes with some of this transition planning. So it's something to families should be thinking about and preparing for. I think it's becomes most urgent as the child is getting older, but for a number of things. For example, I had a client where the parents were suing kind of like a malpractice at the time of birth, that the child lost oxygen and ended up, I guess, being diagnosed with a particular disability. And I remember talking to this parent about, if she does, win in a settlement or in court, the money, that's, and she was like, she was going to put it in a special needs trust, and that was how she was going to, be able to protect her child, moving forward. And this was even a young, this was like a toddler. So she was already kind of, planning ahead, like, this money, wasn't going to be, for her and her husband to start spending or whatever they were going to do, but to kind of save, put it aside, and then it wouldn't impact him as he gets older and needs access to some of these, government assistance.
Yeah. Thank you so much for that. I do want to make sure we get to Audrey's hand. Audrey, if you can unmute.
Hi, can you hear me?
Yes, we can hear you now.
Perfect. So I know all of our children, we lost so much time because of the pandemic. Is there any possibility for DOE or the state, I don't know how it would work, to extend the age to maybe 22, opposed to trying to get back compensatory time and compensatory related services that were missed during the pandemic?
I know there was some advocacy around that. I remember seeing things maybe in definitely 2020 and also 2021 last year about extending a child's eligibility for special education services. So if they were in that category of turning 21 in that particular school year, but understanding that they missed out on a whole bunch of education, but it's compensatory education. It can allow a child to benefit or to receive special education services beyond the period of eligibility. And so that was always the case, even before COVID, was that, okay, just because you're 21, things are supposed to stop, right? At some point, education is done. But if there are still claims, if there were still claims within the past, the most recent 2 school years or calendar years, however you want to think about it, then parents were still allowed to bring a claim and say that. So in terms of a not necessarily a policy shift, but a statutory shift to extend that time, to say 22 years old instead of 21. I don't foresee that happening at this point. I think, to change the law just requires a lot of steps. And so I think even if it can happen, I don't think it's, definitely not for the kids that are, 21 or 20 years old right now. I don't see that being feasible, just knowing the state of, laws and Albany and things like that, the politics of it. But from just a pure special ed perspective, if a potential client came to me and said they felt like, over the past 2 school years, their child has, made either minimal progress, didn't get the services on the IEP, or the services on the IEP were inappropriate to begin with, there's still a viable claim for it. But it's going to look different. I mean, I don't know if they're going to have, a hearing officer will say this 22-year-old or 23-year-old should sit in the high school that they were attending before, but it may just be like a bank of hours that I see that more commonly of, well, here's some private tutoring and this is going to help you move on to the next stage of what your post-secondary life, and then that is what would be ordered.
Thank you. Thank you. Do we have any further questions for Ms. Mpi-Reynolds? Thank you for your time and this presentation and just giving to the community. It is really something awesome. We're going to make sure that we have this online, but I do want to double check, does any other attendee have a question for Ms. Mpi-Reynolds? No. Well, we do have one final question for Ms. Wright, one of the panelists that we didn't get a chance to get to. Could you tell us about some of the signs that a parent might be looking for or need to be aware of when it comes to their child in ADHD or ASD, and what may be, if something doesn't seem typical for their age range, what are some of the things that they should be looking out for behavior-wise?
Sure. So that's for me, right? Not Miss Wright.
That one actually is for Ms. Wright.
Oh, okay. Because I could just speak from my client's perspective, but Ms. Wright, I know.
If you can jump in on a little bit of that too, I would love.
All right, I could finally, can you guys hear me now? Because I was
Yes.
unmuted. All right, who would you like to say to answer?
What are the signs to be aware of when a child is having behaviors that would not seem typical for their age range?
You want Miss Reynolds to answer or me? I don't know.
You can lead it out, Rebecca.
Okay, I can lead it out. Well, I will say this, I always go towards the tantrums. A lot of people would say there are that tantruming and being cranky and wanting their way and being rigid could be normal to a certain extent. However, when we talk about the diagnosis, we're talking about longer periods of time. So you'll have children that have a diagnosis, they'll say, oh, that's typical, but then the children that have the diagnosis, it's beyond the normal time. So the tantrums are happening more frequently, longer in duration. It's a little bit more intense than a typical developing child. So I'll start with the tantrums. Also, you might have children that, they might be, well, they're shy. Well, they're shy, and then there is some signs where you notice that there's avoidance of eye contact or wanting to play alone, or just really avoiding any type of social contact with any child. Or I've heard this, well, boys, it takes a little bit longer for the boys to start talking. I've heard pediatricians say that. And again, when I mentioned in my presentation, just, some healthcare providers are still learning a lot more about autism. And I did some research that a lot of them are not following the checklist. They're not following through with the screening that they should, but that's another topic. But to say that a child, oh, well, boys, or he's a little delayed, he'll come and he'll catch up later on. It's different when the developmental milestones are not being hit in the sense of communication and the communication piece. So these are things to look out for. Just know that it's a little bit more extreme, a little bit more longer and exaggerated in the behaviors and it's beyond the typical time.
Okay, thank you so much. Ms. Mpi-Reynolds, you wanted to touch on that or?
Yeah, just very quickly, because I know I had for another group, I had done a presentation about, the warning signs and why your child may actually need an IEP. So just really briefly, the standard is if there's an adverse impact on your child's educational performance. So a decline in grades, a change in their mood or mental health status, irritability, if they're having difficulty concentrating, school phobia, being fearful of getting out of the house when they know they have to go to school, very general, social and behavioral difficulties, difficulty keeping up with their classmates, of course, complaints from teachers, that's always a red flag. And then any, increase in disciplinary infractions. And then if supports that are already available, like AIS, academic intervention services, I know it's called something different now, if those things aren't working, these are all, I think, signs that perhaps getting an evaluation will help clarify what's happening.
Okay, perfect. Thank you so much. Before we end our conference with our acknowledgements, I do want to let everyone know This information and these sessions will be on our website. Resources will be sent out to the people that attended. It will also be available on ccd75.org. Everything that you need. If you just want to go to the website, we should possibly have that up and working before Monday. That is the goal. I do want to say thank you to all of the presenters and for your time. And I do want to take the space to thank the people that helped pull this together. And with that being said, I want to toss it over for acknowledgements to Amy Ming-Tsai, my co-chair for outreach.
Thank you, Christi. And it was an honor to work with Christi as well in the planning stage and preparation, alongside our other council members, Christi Montalvan and Constance Isudu, who we all worked really diligently to make sure that this conference was well resourced and from the great presenters here who have great knowledge from their professional and personal experiences. And then also to our entire council for making sure that this conference will work and run efficiently today on a Saturday. So we just wanted to acknowledge our presenters who took the time to create their deck and also preparation for being here today and staying on. Ryan Grimes, who is a certified pediatric nurse practitioner who has expressed her experiences through students and families through their journey. And Rebecca Wright from Right Way Care, Lala Yusubuva, apologize again, who's the executive director of Spark Kids. Thank you for sharing your program and expressing the need for our community, and hopefully we'll get more services for this program. And from Wendy, who is, I apologize, Wendy, who's from Adapt Community Network, and Francis from Manhattan Transition and Access Center, and lastly, Oroma from Legals. I apologize, I'm reading from a script. MSR Legal and Consulting Services. Appreciate all of you being here and staying on.
Don't forget the survey. Don't forget the survey.
Yes, I will. Thank you so much, Craig. So please complete the post conference survey. Give us a little bit of feedback as to what you like, what can be improved, what maybe next time we can add to our conferences, and really hope that we can continue. This is actually our first, and we see a wealth of knowledge that our families are getting. We hope that they really enjoyed and be empowered that you're not alone in this journey with your child and your family, but there are support teams here. And there's lots of people here also can connect you to other organizations and agencies. So we will have our survey linked in the chat as well as on our website, ccd75.org. And please also follow us on our social media platforms on Facebook, Twitter, and if I'm missing one, Christi, please add. And we'll also share all the information. Great. And then we'll share all this information. And we know that, you know, families unfortunately today weren't able to participate here because there's so many things going on around the city. So you would have an opportunity to view the clips of every session on our website. Christi will get that out to you soon. And again, I know there was some technical things that happened earlier, but thank you for just following us through the end of this. And we will stay on. If anybody wanted just leave their information in the chat box or questions or just need a little guidance, we're here, we're gonna stay on, but please take the beautiful day to enjoy with your families and stay hydrated with water and grab a snack. We know we've been here for a while and we will be back for another conference soon. So thank you so much and good afternoon now.
Yes, thank you. Have a great day, everyone. Mr. Spencer, did you have anything that you wanted to add or?
Yes, ladies and gentlemen, this coming Wednesday evening, our council will be leading, along with 3 other parent bodies, the superintendent candidate town hall. Start at 7:15 to 9:15 p.m. Please email our council, d75council@schools.nyc.gov. If you didn't get the link, it's not through us, it's through the DOE. But we have 2 candidates. There's questions. There'll be questions from the chat that the candidates will have to stay to field. So please, and this is the work that it took a lot of work. We need to get this to you to empower you. So please be on the lookout for that. Christi, I'll work with you offline to make sure that that connection is, because we don't have the connection. We don't own it. We didn't make it. Our next council meeting, a joint meeting, is June 15th. That's the last one of the year. There's several things will be going on. We'll hopefully, cross our fingers, have some information more on summer instruction. And we're trying to set up a meeting to get more information to give you. There'll be wrap-ups of this and other events. So yeah, the most important thing is Wednesday night, 7:15. Superintendent candidate town hall. Get it. It's about 20-25 minutes for you guys to ask questions in the chat. So please pass that around. We'll get that out as much as we can. Thank you so much.
Well, guess I need to unmute. With that being said, thank you again. Thank you very much, Amy Ming-Sai, my co-chair, for all of the council members that have supported today. I did see Patricia Hewitt, Celia, Joanne, Craig.
Aisha, she came in. Thank you.
Aisha, yes. Aisha is here as well. So thank you once again. Do expect to watch these online. And if you need anything else, please feel free to reach out to our council. The council email is d75council@schools.gov.
Schools.nyc.gov.
.nyc.gov. Thank you so much. All righty, everyone, have a great day. And
Stay
thank you
safe,
again.
everybody. God bless.
Afternoon.
We staying on. We're good. Oh,
Yeah,
I want to stop the
for
recording.
a brief second.